Okay, council, I'm just waiting for the jail to connect and then we'll get started. Before we do that, Mr. Brown, did you have a chance to speak to either or both of the individuals?
Yes, I did, Judge.
Okay. I'm not sure. Do we have anybody connected from district court?
I see Pam there.
Oh, I see. It looks like you're muted, Pam. Oh, there. Or your microphone might not be turned on. Either way, that's fine. If you can hear me, can you give the jail a call and let them know that we're ready? Thank you. All right, there at the jail. Sir, can you tell me what your name is, please?
Ryan Clous.
Mr. Clous, okay. 1 second here. Okay, we'll go on the record. This is People versus Ryan Allen Clous, case number 2442954-FY-3. This is arraignment on a felony charge here. And for the record, the court is presiding over this matter on behalf of Judge Cooper here today. If I could have both the attorneys put your appearances on, please.
Thank you, Honor. For the record, my call on behalf of the people.
Larry Brown on behalf of Mr. Clous.
Okay, Mr. Brown, you've had a chance to talk to Mr. Clous today.
I guess I have, Your Honor.
Have you had an opportunity to go through his rights with him?
Yes, Your Honor. As the court probably remembers, Mr. Clous was recently sentenced by this court just last month.
Right, exactly. Have you had a chance to go through this new charge with him?
I have not, because I mean, it was a larceny in a building is what he's charged with. He was unaware of what this charge was, or didn't really have knowledge of it. And I guess I'm a little curious because actually I just a couple of seconds ago here just received the summons on it. The date of the alleged offense was August 12th, which was looks like today. I thought he was under sentence and in jail.
All right, Mr. Rolla, maybe can you shed some light on this for us,
I
please?
can, Judge. That the date should actually say August 10th. It was Saturday, early morning hours. I know because I had to come in and do the warrant for the matter and to enlighten the defendant on it, since he admitted to the theft law enforcement officers regarding stealing silver dollars from the residence located at 310 North Otsego Avenue, Apartment C. I think he should have a very good memory of what it is. In addition, as to the confusion that Mr. Brown has, the people were also confused because supposedly back on July 3rd, 2024, in case number 246718FH, Mr. Clous was sentenced on a charge of larceny in a building. He was given a sentence of 6 months with credit for 9 days. And how he can be out on jail on August 10th, I have no idea.
Hey, Mr. Clous, were you in jail on August 10th or had you been released?
No, I actually just got back from rehab. And then I was gonna be coming back to jail the next day.
So you were out of jail in rehab when this charge allegedly arose on August 10th. Is that correct?
I just got back from rehab. Like, I just took the bus back to my house. I just got home.
Yeah, but you weren't in jail is my point.
No, I was not in jail. No.
All right. So Mr. Brown, I'm just going to treat this as just a typical arraignment on felony charges, and we'll go from there. So Mr. Clous, I'm going to advise you of all of your rights today. And we'll set this matter for a hearing, and we'll go forward with the normal procedure. So, Mr. Clous, you're charged in this case with 1 count of larceny in a building. The complaint alleges that you did commit the crime of larceny in a dwelling at 310 North Otsego Avenue, Apartment C, by stealing 4 silver dollars. And you're being charged as a habitual third offender, and that makes the maximum possible penalty in this case up to 8 years. Do you understand that?
I do.
Okay. You do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at a trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all your rights?
I do.
Okay. You also have the right to have an attorney present at any subsequent proceedings. If you cannot afford attorney, one would be appointed for you at public expense. Mr. Brown, my understanding is that Mr. Clous has already been screened and approved, and you've been assigned as his attorney. Is that correct?
That is correct, Your Honor.
Okay. What plea do we want to enter here today as to this charge?
A not guilty plea at this moment, Your Honor.
Okay, so Mr. Clous, the court's going to enter a not guilty plea on your behalf with regard to this charge. And then we'll set this for a pre-trial hearing. That's going to be your next appearance in court. That's going to be on August 21st at 10 a.m. And we'll give you a written paper that gives you all the dates and times of your hearings coming up. In terms of bond, pending that hearing, I believe bond was already set at $5,000, 10%. Mr. Rowland, are the people asking for any kind of modification of bond?
Judge, it all depends. If he was supposed to be returning to jail, which as I understood he was supposed to after getting out of rehab, he may very well still have time left on his sentence in case number 246718FH. If he does not,
I do still have time. Hold
on, Mr. Clous.
Okay, go ahead, Mr. Rowland.
Thank you, Your Honor. If he does not, then yes, the people would specifically ask for a higher bond, because clearly, after being given the benefit of going to rehab instead of going to, quite frankly, where the people asked that he would be sent, if the court recalls, and I don't remember if it was your case, Your Honor, or Judge Hunter, I'm looking now, but this is the one where he was convicted of stealing multiple bottles of vodka from Family Fare, charges of larceny in a building because he also stole the caps that are not offered for sale, and then was allowed to go to rehab in lieu of immediately going to jail and staying there. So this is a situation where clearly he is not going to follow the orders of the court. And if he, as he indicated on the record today, returned from rehab, but did not immediately turn himself into the jail as he was required to do, but instead went home, that's further indication he's not going to follow the orders of the court. And we think if there's not time holding him in jail on the other charge, we think a higher cash bond is appropriate, or he's just going to continue to get intoxicated and continue committing larcenies as he's done for what, the past 15 years.
Thank you, Mr. Brown.
Thank you, Your Honor. And this case, again, just came up this morning. I am familiar with his previous case. This court did sentence him to 6 months in jail, 9 days credit. He could be released to residential treatment if a bed was available. I guess I am not that familiar with the inner workings. Apparently, it may have been up to him to transport himself and transport himself back. Because that is the only way that these alleged charges could have occurred on this date. But this was back in July 3rd, so he still has another 5 months to serve. To be quite honest with the court, bond is not going to matter at this point because he is serving another 5 months in jail.
All right, I mean, I'm satisfied that Mr. Clous, based on his previous felony case, is going to be lodged for at least the foreseeable future in terms of the next few dates in this new case. So the court is going to leave bond as set by the magistrate at $5,000, 10%, subject to all the conditions set by the magistrate. And then again, this case will proceed on August 21st with that felony pretrial. Mr. Rolla, anything further that we need to address from your side on this file today?
Judge, just the only, and I guess I understand the court's ruling, but I'm a little bit confused as to how he could even qualify for a 10% bond if this offense was committed while he was under sentence for another felony. But in any case, since he's serving time, it's at this point effectively a moot point. So I'm not going to belabor the matter, Your Honor.
Okay. All right. Thank you. Mr. Brown, anything further from your side?
I have nothing further substantively, but if the court could please just give me that file number one more time.
This current file number?
Yes, Your Honor.
Sure. This is 24-42954-FY-3.
Thank you, Your Honor. I have nothing further.
Okay. Mr. Clous, do you have any questions before we move on to our next case?
I don't, except that was actually, the address was my house. Just to let you know.
Mr. Clous, don't talk about any of the facts of this current case.
Okay, that's fine. That's fine.
Okay. All right. Thank you. And if there's a jail officer in there, if we could have Mr. Heron next, please.
Yes, Your Honor.
Thank you, Your Honor.
I know, I got one not that long ago, and it was the first one they covered. I'm like, I don't know. What? Oh, absolutely. Yeah.
All right, sir, is your name Jason Heron?
Yes, sir.
Okay, we're on the record now in People versus Jason Heron, case number 2139608-ST-3. If I could have counsel put your appearances on the record, please.
For the record, Your Honor, Mike Roll on behalf of the people.
Larry Brown on behalf of Mr. Heron.
All right, the record should reflect Mr. Heron's appearing today by video from the Otsego County Jail. Mr. Heron, you're before the court here today, basically for two reasons. Number one, for your failure to pay fines and costs in this case. And then number two, for your failure to appear at a hearing back on March 14th of 2022 to show cause why you haven't paid your fines and costs in this case. Do you understand why you're before the court today?
Yes, sir.
All right, Mr. Brown, did you have a chance to speak with Mr. Heron?
Yes, I did, Your Honor.
Okay, is Mr. Heron, I know that at the time that the bench warrant was issued, bond was set at $500. Is Mr. Heron going to be able to post that, or is he going to be able to, you know, I guess the way I would proceed with this is if he can make some kind of payment towards the fines and costs, the court would set that amount as the bond amount so that he could be released and then have this set for a hearing.
Your Honor, the underlying charge here, was he already convicted of that? Is this just a fines and costs matter?
I mean, I'm sitting on this case on behalf of Judge Cooper. Based on the paperwork I have, it looks like he was convicted of operating without a license, that he was assessed some fines and costs, that he failed to pay those fines and costs and was ordered to show cause back on March 14th of 2022.
And
That's what
Judge,
it looks like.
for the record, that's what our notes indicate. He apparently pled on August 2nd, 2021, and then was sentenced on November 10th, 2022.
Your Honor, as it goes to the alleged failure to appear, I did have a conversation with Mr. Heron. He did give me what, especially given this case is about 3 years old now, he did give me what I at least thought could be a plausible explanation. I would have to defer to him if there is any amount that he could pay to these fines and costs as it relates to potential bond here.
Mr. Heron, is there any amount that you can pay towards these fines and costs today?
At this point, I came in with nothing. I have to finish a drywall job in my brother's basement in order to get paid for the job. Then I can make, if you can make a payment plan with me, I can pay it off. I can pay it off. I'm working 3 days a week, but you know, but I have to finish the job, the drywall job, in order to get paid before he had somebody else finish it for me.
All right,
As right now, I don't have nothing. I don't have a dime to my name right now. But
Right,
if you can make a payment plan with me, I can most definitely get it paid off, sir. I mean, when I get home, I can send something back, you know, $50, $100 or something, you know, I can get.
Well, here's the problem, Mr. Heron, here's the problem from my standpoint, and I'm going to hear from the prosecutor about how he wants to proceed, but this case has been out there for 3 years and you haven't made any payments. So what assurance do I have that if I let you out today, you're not going to just disappear for another 3 years?
I'm not gonna do that, man. I'm trying to get all this behind me because I don't use, I don't drink, I don't smoke cigarettes, I don't smoke weed, I don't use no hardcore drugs. Trying to get stuff, excuse my language, trying to get stuff back right in my life. I got a little one I got to take care of. So yes, I don't want to be 3 years behind again and this come haunting me again and disappear on my loved one. So I will, as my word, as a man, today, I will pay on it. I will pay.
Mr. Rolla, what's the people's position?
Judge, again, I think the court said it pretty clear. The people would be interested in what the defendant's current address and phone numbers are, so whether or not he can even be contacted, because I'm not sure if the information the court even had was viable. And that may also make an impact on what kind of bond the court would be willing to set.
And
What is
I moved
what is
out. Oh, I'm sorry.
what is your current address, Mr. Heron?
Well, I'm living on 302 Moss Street, Moss Ave, Ypsilanti, Michigan.
So how did you end up here in Otsego County this morning? How did you get arrested?
Through Arraignment came and picked me up from Washington County. Like I said, I got picked up on a bench warrant trying to take and making my rounds, trying to take care of everything. They've PR'd me, and then Arraignment, I did the 6 days for them, and then you guys come pick me up. That's about it. And the reason I moved from back up here is because the house I was living in, the roof fell in, the kitchen roof fell in, and it took $1,100 a month just to heat the house. I couldn't afford that.
All right.
So after the roof fell in, I moved back downstate.
So tell me that address again, please. The current address.
302 Moss Ave, Ypsilanti, Michigan.
Okay. All right. Well, here's the thing, Mr. Heron. I mean, your previous address that we have here is in Hillman. Obviously, that's not a good address. You're not living anywhere. You're not living anywhere in northern Michigan, anywhere close. It's not like you came in voluntarily and turned yourself in on this warrant to get it taken care of. I don't really have any assurance that if I release you on a PR bond here today, that you're not going to just disappear until the next time you get arrested and get brought before the.
Yeah, I promise. I swear on my little one, man. I swear on my son and my mama is in heaven. I will not disappear on you without paying. I will send it in the mail. I will send it in the mail. I swear.
I'd be inclined to believe you if you had done something about this before, but again, I don't have any reason. I don't have any reason to believe that. So the court's going to leave bond set. The court's going to enter a not guilty plea on your behalf with regard to the contempt for the failure to appear, and the court will set this for a hearing in front of Judge Cooper, and Judge Cooper can decide how he wants to go forward, both as to the failure to pay and the contempt for the failure to appear.
Well, if I was to give something today, what would I have to give today if I can get a hold of somebody to help me pay something?
$500 is the bond.
Oh, because you said it like if I was to give something today.
Yeah, $500.
My people can't afford $500 right now, Your Honor. Like I said, that when I was living in Hillman, Michigan, the kitchen roof fell in, and it was black mold. It was this all tight, $1,100 to heat the house. It was just too much, and it was time to go. You know what I'm saying? I had nowhere else to go but back downstate.
Yeah,
you know, I mean, the house in Hillman was just it was 201 West 2nd Street, Hillman, Michigan. That house is a wreck. They should turn it into a parking lot. I mean, the whole house is just falling apart. The back porch fell off. The side porch fell off. The house is crooked.
That really doesn't have anything to do with what we're dealing with here today. So,
That's
Mr.
the only reason I left.
People.
No, Your Honor, thank you.
Mr. Brown.
Oh, Your Honor, thank you.
Okay.
So if you give me a chance, I can do it. If you just give me a chance, I'll pay something.
You had a chance since 2021 to get this taken care of.
But I was out of work, sir.
I hear you.
I couldn't even afford the house I was living in.
I understand. That's all for this hearing today. You'll be notified of the date and time of the hearing in front of Judge Cooper, and we'll go forward from there.
How,
Where it's gonna go
where-
next.